Now let's listen to the approach that Keith Davidson would take to fight for your inheritance. So in this scenario, we had a sequence of facts that have occurred where you think that the estate plan has all been taken care of. Your father has told you that everything's going to go equally between yourself and your sister, and you just assume that that's what's happening, and you really don't give much thought to it. And then after your father passes away, we find out that everything is completely different from what you expected. So in this scenario, rather than getting half of your father's estate, which is presumed to be about $3.5 million, you're getting a specific gift of $250,000, which is still a significant amount of money, but it's nowhere near as much as what your sister is going to be getting, which is $3.25 million. So the question then becomes, what can you do about it? I would choose option number 2, to file a trust contest. The reason I like option number 2 is that there's a lot of things that don't seem right with that last trust amendment. It was created about a month before your father died. It was created during a time when he was suffering from medical ailments and had mental issues. And it seems as though your sister was pulling a lot of strings behind the scenes to get this trust changed to her benefit. That could be a classic undue influence case. It may also be lack of capacity, depending on what the medical records would show for your father's mental condition, but it most likely is an undue influence case, because it sounds like your sister actually exerted undue influence on your father to get this new trust created. So the trust contest is the only way that you can go and challenge that trust creation and claim that it was invalid due to undue influence. And if you can prove that claim up in court, then you can actually invalidate that last trust and everything would go back to the way it was supposed to be, 50-50. I also would consider filing a financial elder abuse action, because undue influence, while it can be used for trust contests, it can also be used to form the basis of a financial elder abuse action. And it appears as though your sister has engaged in financial elder abuse by taking the assets from your father through this trust transfer gift that she created. So she had him create this trust. She now is taking all of those assets. And under the financial elder abuse laws, that would qualify for financial elder abuse. You could file that claim. That'd be a claim that you could file in civil court. You could also file in probate court in conjunction with a trust contest claim. You'd have to figure out which way you want to go on that. But those are the two causes of action that would most likely get you what you want, which is to restore the estate to what it should have been. I wouldn't choose option number 1, contact Bernice, because I think at this point you know darn well that Bernice is not going to talk to you and is not going to do you any favors. If Bernice went out of her way to try and create a trust that favors her and disfavors you so much, I don't think she's going to change that now after death. So in my opinion, contacting Bernice is not going to get you anywhere. I also would not bring an intentional interference with an expected inheritance claim in this particular case, only because I don't think you could bring that type of claim here. As long as you have a probate remedy, a remedy that you can bring in probate court, then you cannot bring an interference claim. And here you do have a probate remedy because you can bring a trust contest claim. So that's the better claim. That's the one I would go with. And number 5 is do nothing. That obviously is a very individual choice. If you really didn't want to get involved in litigation, you don't want to get involved in the court process, then you could choose to do nothing, take your $250,000 and go your separate way. Obviously, for somebody who's interested in fairness of this situation and wanting to make it right, doing nothing isn't really an option. But it may be an option. That's a personal decision that you have to make to decide what you want to do. So of the options we had, options 2 and 3 are the options I would go with to try and restore this trust estate to what it should be.